Hello everyone, and welcome to the Firearm Firm channel. Unlike some of our recent videos discussing attacks on the Second Amendment, today we are talking about a victory for the Second Amendment. Yesterday in Texas, a federal judge ruled that based on the recent U.S. Supreme Court decision in New York State Rifle and Pistol Association versus Bruen, that 18 U.S.C. 922N is unconstitutional. Here is a brief breakdown of the facts in the case from yesterday's ruling. The defendant, Jose Quiroz, while under a felony indictment for burglary, attempted to purchase a handgun. He lied about being under a felony indictment on Form 4473 and after a short delay took receipt of the handgun. He was then indicted for lying on the Form 4473 and for receiving a firearm. A jury ultimately found him guilty of both charges, but he then filed a motion for reconsideration based on the recent decision in the Bruen case. The court ended up granting his motion and wrote the following in the conclusion to their order. The Second Amendment is not a second-class right. No longer can courts balance away a constitutional right. After Bruen, the government must prove that laws regulating conduct covered by the Second Amendment's plain text align with this national historical tradition. The government does not meet their burden. Although not exhaustive, the court's historical survey finds little evidence that 922N, which prohibit those under felony indictment from obtaining a firearm, aligns with the national historical tradition. As a result, this court holds that 922N is unconstitutional. It is therefore ordered the defendant's motion to reconsider is granted. The indictment is dismissed. The Second Amendment is not a second-class right. Those are strong words and music to my ears. Of course, the government did file a notice to appeal, so we are going to have to see what the appellate courts have to say. But this decision is definitely a step in the right direction. Now, as all you can imagine, anti-gunners are all riled up about yesterday's ruling, yelling about how this is going to increase gun violence because now criminals can get guns. I hate to be the bearer of bad news for them, but this ruling means absolutely nothing to criminals. They are going to get their hands on guns and commit crimes no matter what the law says. Anti-gunners need to remember that criminals are criminals because they don't care about the laws or the consequences of breaking them. What this ruling really does is allow the innocent individual who has been accused of a crime but not convicted of that crime an opportunity to protect themselves or their loved ones. Remember, an indictment is just an allegation that someone has violated the law, and until the jury finds that person listed in the indictment guilty of a crime or the person enters a plea to the crime, the Constitution presumes that person to be innocent. We have all heard innocent until proven guilty, so why should someone who is under indictment but has not been found guilty automatically lose their constitutional right to bear arms? They shouldn't. At Katz & Phillips PA, we often represent individuals who have been forced to defend their lives only to be arrested, have their firearm confiscated for evidence, and prosecuted for a crime. To make matters worse, if that was the only firearm they owned, now they cannot purchase another one to protect themselves or their loved ones from retaliation against the true criminal. In some criminal cases, it can take years before the case is closed, so that person who did nothing but defend themselves would have to wait out the life of the investigation without protection. So this ruling is great for the 2A community and does not give criminals any new advantage like some think. Tell us what you think about this new ruling in the comments section below. Be sure to show your support for the Second Amendment by clicking the like button, and if you are joining us for the very first time today, be sure to subscribe to our channel. Until next time, stay armed and educated.